Okay, well, I'm glad to hear that. I apologize for the 15-minute delay. I was airdropped into a hearing on Friday and got someone else to cover it, WebEx up in Avery County, where they're having more fun now than they can stand. So I welcome everybody. It's a nice, small, select group, and we'll be talking about proportional discovery today. You have some materials for review, and probably the bulk of those are with regard to the changes to the Cognate Federal Rule 26, where at least they skirt up against the issue of discovery that's disruptive. I'm thinking of two cases, one out of Forsyth County with a judge now on the bench, Mike Robinson, where there was like a $60,000 fine assessed against a very fine local law firm with regard to subpoena of documents that were determined by the court to be overbroad. And I unfortunately represented the party on remand from the Court of Appeals in that matter, trying to get the costs that were assessed tamped down. It was by an out-of-county judge who's no longer on the bench and shall remain nameless. But we did finally get rid of that thing. And if you read about the doomsday motion last year in Lawyers Weekly, we had not a law firm, but a party defaulted for concealing and withholding documents. That went up to the Court of Appeals, which quickly reversed for reasons I'll never understand. But that sort of gives you the array of discovery abuses on both ends that we see in this and other jurisdictions. So I suppose that this issues committee assignment was prompted by that sort of documented abuse that occurs with regard to discovery. And in talking about proportional discovery, I thought the first thing I would do is ask for a report from anybody who's actually engaged in discovery under certain restrictions. And I don't just mean an IPC order from the federal court where they set, how many depositions and interrogatories and how many months you can do it and that sort of thing. But really where there's a very trimmed down schedule. And the only analog that I can come up with, and a couple of you may know about these, I do a lot of medical work, was when they passed that arbitration statute under Chapter 90 over a decade ago. Yeah, it was actually 2007. And in that document, if you opted for arbitration in a medical negligence case, a Chapter 90 case, then you were subject to that statute, which had some substantial restrictions on the parameters of discovery. You had like 25 interrogatories, 10 requests for admissions. That was your limit. You could depose the parties and you could depose any experts. Other than that, you're pretty much on your own. And my point is this: given the restrictive or at least defined parameters of that statute, I never got to do one. I never had anybody that would opt for one. I finally did get a plaintiff to agree to one about a year ago. And as soon as that was signed, the matter settled. So I've never really participated in what I would call that type of proportional discovery. And I guess I would ask our committee if any of you have. If so, let's hear it.
I have not, Greg.
Yeah, I haven't participated in that type of proportional discovery type case, but I did. We just had a case 2 weeks ago, I guess, that we went before a 3-judge panel on a challenge. I guess it was we were defending a motion to compel, and in this we had we're involved in this voter ID. There's a challenge to the voter ID constitutional, the enabling statutes that are for the voter ID constitutional amendment. And it was before a 3-judge panel on the subpoenas that were issued to the, most of the colleges in North Carolina to produce student records. And this proportional discovery was one of the main arguments defending against this subpoena. And it was interesting to hear the court's view, this 3-judge panel's view on the arguments. And they were, I guess I was surprised at how receptive the judges were to the arguments, and which was good for my client. But they ended up essentially granting, or I guess they denied the motion to compel and accepted our arguments that the discovery requests weren't proportional in the case. So I thought that I was actually expecting that the judges were going to read the sort of go with the, if it's, you know, relevant to producing admissible evidence that it should be allowed type discovery standard. And they did not accept that. They were very receptive to the proportional discovery.
Well, whatever you say carries authority. I see a cannon mounted on each of your shoulders here.
I find that to be very helpful in these times.
Walter Brock, you must have had some experience with proportional discovery.
Most of mine has been non-proportional discovery that I've struggled with. The case Gray, I think the case you're referring to, the Court of Appeals, that got reversed, where there were discovery sanctions for failure to disclose information, was our firm. I'm not working on the case, but it's one of my team partners, and I'm
it was
familiar
not your
with
firm.
that. Huh?
It was not your firm. I was referring to another matter.
Okay. Well, there was a recent one where Judge Hobgood just nailed the defendant.
I saw that.
And it shockingly, the Court of Appeals turned that around and remanded it. I can only imagine that the same thing will happen again. It was very abusive in refusing to answer discovery in that case. But I think to me, the biggest, the biggest expense and the most difficult thing to proportionalize, for lack of a better word, is electronic discovery. And it has become, I don't know if it's for you, but it's become a nightmare for me. About any significant case you get involved in, you're dealing with e-discovery, and you've got to bring in, consultants. You've got to bring in, the management software to handle all of that, and trying to figure out how to bring all that within some sense of proportion is very difficult and
expensive.
Yes, it is tremendously expensive. And I don't know how to get a handle on that, quite frankly. We have had some limited success, and it was because, you ingest all these electronic documents. And then I think the key to making it proportional is that the parties simply agree, we're not going to, when they say produce all documents, everybody agrees, okay, we will consent or stipulate that you can run these word searches or these key term searches with these particular folks who have, the email custodians, with this certain email custodians and certain terms. And to me, maybe that's where lawyers can help get this under control, because if we are reasonable, we can all sit down and say, there may be some other magic document out there that nobody knows about that we might find if we require every single document to be, looked at. But in most cases, I think maybe if not all cases, we can agree that there are certain key search terms and certain custodians who are material to the issues in the case. And if we can work together as lawyers on those things, the ingesting of the electronic discovery is expensive enough, but actually reviewing it page by page is, it's incredible how much time that actually takes. And one thing that occurs to me is we can figure out some way to encourage lawyers to agree on how to search documents, so we don't have that free for all where you got, and also, on the backside of that, having an agreement that you can recapture stuff that gets sent out that actually may be privileged or work product that your searches didn't disclose, and just have an agreed or stipulated order that allows you to recapture those things if they do turn up. And those two things, I think, might be a solution to many of the problems that I've faced in discovery in the last few years. Just those two tools.
Ray, can I ask a question?
Sure.
I do nothing but criminal law, but is the problem the request for discovery that we're looking for proportionality, or do we have a problem with the other opposing party dumping more discovery to try to hide the ball, sort of, or is it both?
Well, it's primarily the former, I would think.
Right.
I don't think lawyers really mind, crawling through those. But what Walter touched on, I think, is significant. Of course, the federal rule 26B5 has clawback provisions in it, and I think that's appropriate. And then in your IPC orders that are entered in our district courts in this state, they'll have a section in there where you're supposed to respond, just as Walter indicated, about what you're going to do about e-discovery. We have e-discovery in the North Carolina rules now. Some people will put in there the parties agree that there aren't any issues or problems anticipated with e-discovery. Others will have it in there in native format. Others will have it in there with every kind of metadata you could have, so that whatever document you produce, they can, go through and statistically check and piecemeal to see how many times, the word lugubrious appears in documents, and there's thousands of documents that are produced. So it's certainly an issue now that didn't exist 20 years ago, even this e-discovery. But anybody else have any particular specific thoughts that, or not just thoughts, encounters you've had with regard to discovery in terms of abuse or problems with regard to proportionality? We've got our bar, state bar people here in force, and hopefully they, get us over the threshold of this being part of our regulatory mission, just because of the chronic abuse that appears to exist in the system on both sides. Any comments on that before we try to get a little more specific about what are we going to do about it?
So, Gray, I'm interested in being able to articulate, since I know you've done your homework on this, about the, for lack of a better term, the jurisdictional basis upon which we, as a state bar council and as a subcommittee of that, have maybe authority is not the right word, but at least some basis for us getting into this, this territory of abusive discovery, and help me be able to articulate to others where we see this is carrying out the mission of the state bar as a primarily regulatory body.
I think one of our Office of Counsel here might want to address that.
Catherine?
That's for you, Carmen.
Well, I think that, if I understand your question correctly, oh, hold on, we have someone else joining from the waiting room. The question is really what does the state bar as an agency have to say about what the rules of civil procedure provide for? Is that the question? Because we do certainly have rules of professional conduct that address discovery abuses. They have to be rather severe. I mean, I think before the rules really come into play and they become a matter of disciplinary regulation. So maybe I didn't understand your question. Was that your question?
Well, you're sort of dodging it. That was pretty close. Yeah. I think this is an important issue, and I think we can be helpful to our membership and to the bar and to the courts also if we can provide some guidance. But by getting into this, I think we need to be well based within our rules of professional conduct and any of our ethics opinions and things of that nature, well grounded in that as a basis for us to venture into what I think is an important issue.
Well, if it would be helpful, I mean, I can compile the provisions of the rules that apply to discovery and any ethics opinions that we have on discovery issues. Just if we want to start there as a foundation, that I could certainly do that.
That would be helpful to me, especially if there's pushback from folks who think we overreach. I can't imagine that there are any of those, but I've heard rumors about it.
I'd be happy to.
I think we have a new member of the committee who's joined us. See Marcy Armstrong. Welcome.
Let me unmute.
Yeah.
Hi.
Hey, Marcy.
How's everybody? Sorry.
Right.
I take my mom to the doctor. So
Well, I hope all is well.
thank you. She's 88 and going strong.
Great.
Well, that's a good harbinger for your prognostic outlook. Yeah.
We hope.
Well, we've just been talking about any experiences any of us have really had with proportional discovery and what some of the rules say about it and what the state bar might have to do with it. And since we are streaming live at this point, I thought I would remind our new attendee of that as well.
All right.
Did you have, you practice in a domestic matrimonial law arena? Probably the rest of us do not. And I wondered if you had any particular thoughts or anecdotes to share with us about not only discovery abuse, but actual situations in which proportional discovery has been voluntarily or involuntarily imposed.
Haven't had a lot of time to think about it. I've been on vacation, so my brain is still a little bit lagging today. It's still at the beach, but I have a case right now. The discovery is due on Wednesday, where we got over 100 requests for admissions. I mean, just, I mean, I'm reading them going, you know, take a deposition, you know, or just, I mean, and they're not even well drafted. I mean, I can easily deny them. I mean, but it just is, I mean, it's a situation where I think they're trying to use the process to get my client to take less than he should, just running up the cost. I mean, but then again, there are, you know, cases where you need it. I mean, so, I mean, it's some, but yes, there are definitely cases where you've got one side that has a deeper pocket than the other. And the domestic world, just like in every other type of civil litigation, we're trying to force the other side to take less by bombarding them with discovery requests. So, but our judges are pretty good at, you know, if you file motions, they're pretty good at limiting and recognizing what's relevant and what's not.
They are, but I think we would all agree, to the extent we're all litigators, that there's nothing that a judge hates to see more than a discovery motion in front
Oh,
of them.
yes. Oh, yes.
They want it to go away, and they'll send you both off into a room where you can scream at each other another hour before you come back and say you can't resolve anything.
Yeah, that's true.
And you know, as the rule is mandatory, unless there's some good faith explanation for it, sanctions are mandatory if discovery is compelled. Does anybody have any particular thoughts about whether or not, if we had a more perfect world, there might be some parameters that could be enforced with regard to proportional discovery? And I'm sort of pushing the group right now in the direction of the new changes, I guess the 2015 changes to the federal rule in that regard, which sort of talk about how, you know, with those 6 factors that you've got in your materials, discovery ought to be shaped and fashioned more narrowly than it otherwise would be. You know, it occurs to me, we have a liaison committee with the Bar Association, and they like to propose legislation. And I will tell you that nothing scares me more every year than to read the amendments to the rules of civil procedure that are enacted by our General Assembly. And they just appear to me to be amazingly terrible. But if someone wanted to tinker with our rules, is there any thought here that perhaps one way to do that would be, at least as a minimal gesture, to go ahead and try to incorporate some of the features of the cognate federal rule? To some extent, we used to be just about parallel with the rule, and then they started amending Rule 26 right and left here. But in that regard, what is the thinking of this group with regard to whether or not that kind of legislative change to the actual rule would be something that might alleviate some of the abuse that exists in the present system?
Gray, I guess my first reaction to the federal rule is it wasn't, you know, it really wasn't written to be a substantive change. I don't think it just sort of put it in a place that people had to actually see it and deal with it. And it seems to have helped. It seems to have brought the whole issue more to the forefront simply by moving that proportionality language from the certification part of the rule up to the scope of the rule. And that ought not to be very controversial. And maybe that's something that we can get both plaintiff and defense bar behind and work through the Bar Association, see if we can come up with a suggestion that we use a similar approach. Just let's make that, you know, front and center in the rule and not just buried down there in the certification part. That's just my first thought about it.
Yeah, I mean, I would be in agreement, but I guess I just also wonder sort of what we were touching on before, whether or not there might be some ability to put some type of meet and confer language in there as relates to there. I guess I'm still a little, I don't know, the way that the rule reads now, the federal rule, is not, to me, there's a lot of uncertainty about how do you figure out what is proportional, and how do you know, what is our obligation under the federal rule. And it just seems that it at least the way I read it, and as far as the practicalities of it, is that the parties need to have some discussion about and to try to work to some agreement, like Walter was saying, about how are we going to actually do this? And but the way I read the rule, it doesn't require any type of meet and confer. And I just wonder if it would be helpful to have that actually in the text of the rule.
Well, yeah, something like the initial pretrial conference orders that are routinely issued by the federal court that require the parties to meet and confer.
Right.
And agree on a plan, which includes discovery. Essentially, the initial pretrial conference is a discovery conference, and they want a report. And if you can't give a joint report, then you have, so many days to give separate reports, and then a hearing scheduled, and then the court issues whatever order it's going to issue. But I think the sense you have and that Walter has evinced is basically that the changes to the federal rule in Rule 26 I see them as something of a flanking attack, not as opposed to those two cannons that flank Ted right now. So, I think what you're talking about is adding a cannon, putting some meat on the bones there. But I will tell you that my experience is, and that's why I referred to that medical malpractice arbitration statute, where the parties can voluntarily do that. Nobody voluntarily would do it. So like everything else, at some point there has to be a nudge from a rule or a court for anything to get done, because there are some attorneys, it's shocking how few there are, that aren't very easy to work with from time to time. And so having a rule is nice. Of course, our Rule 26, North Carolina's rule, already has built in there under 26F the pretrial conference that one can invoke there. And there the parties, similar to the federal rule, meet and confer. If they can't agree on things, then they submit separate reports to the court, and the court can, line them up and make them do it. Do you have to do one under that rule? No, you don't. But if it was like the federal rule, you could tweak Rule 26 and say, well, you got to do what's in there. That mechanism is already there. But at this point, unless the court orders it, and I haven't had that happen to me, except in a med-mal context, then it's rare in my experience that in a state court action, the parties actually sit down and hammer out a discovery order. It's mandatory in the medical context, but otherwise, when it's voluntary, there aren't a lot of people who show up for that.
My experience is business court does that too, Gray.
Yeah. Just
about every time business court requires that scheduling order in a 26F conference.
Yes. Yeah. And they pretty much follow the federal rule.
Ray, I admittedly have not had cases where this was really an issue, the proportional discovery. But one of the things that I like you mentioned earlier, Gray, our Superior Court judges do not like discovery disputes. And most of the times, at least in the eastern part of the state with our judges, if a discovery dispute gets raised, it is fixed before the court ever knows anything about it. It is. I haven't had a motion to compel where we actually argued in over 5 years, because we knew what the judges were going to do, and we all came to an agreement. As Walter is saying, if the lawyers would be reasonable, and like, for example, in the e-discovery, it would make a lot more sense. One of the things that concerns me, it won't really impact on my practice, but if a new proportional provision is provided in our state rules, I think that could lead to more discovery abuses. There will be more discovery disputes, more motions filed in our state court proceedings. It's almost like it would encourage additional disputes and more motions to compel over discovery arguments. That's, because we have the certification provision already in Rule 26 in our state rules. And again, I haven't had this issue come up, but I deal with a different type of case. But I do worry about changing the rule and it increasing our discovery disputes, which is certainly not the intention.
Yes.
Well, from those of you who have experienced disproportional discovery, isn't it largely a professionalism question. You know, somebody serving you, not making a reasonable effort to send you tailored discovery or deliberately try to impose expense on the other side. I mean, is that really what it is mostly?
And I think that's what Marcy just said.
Right. So, well, I mean, that seems to me to be the reason why it's appropriate, I think, for this group to look at it and maybe make a recommendation. Obviously, the state bar is not in a position to adopt anything other than just making a recommendation. But for that reason, the idea of the meet and that idea that this is really a matter where lawyers need to get together and find common ground.
I agree, but I think as Charles noted, you know, the problem there is.
Puts it in our regulatory ambit.
Yeah, I agree. I think what Charlie was pointing to, however, is that there's a problem with cookbook discovery where one size fits all. And when you put in those kind of mandatory constraints, would it proliferate more disputes about discovery in the courts than you might otherwise have? And I think he has a good point there. So I can only tell you that in the past, you know, when I've seen proposals where if your case only has, if you're the plaintiff and you think your case has an ad damnum, you'll stipulate the ad damnum is less than $500,000, then you get this box of discovery. If it's up to $1 million, you get a little bit larger box of discovery tools. And I just never saw anybody that was willing to agree or stipulate to anything in that regard so that it would work. So my fear is, as with, and I'm sure the federal system has looked into that, and maybe that's why their current rule is sort of that flanking attack, where they're starting to talk more about it in the rule and giving little guideposts, but aren't putting down anything that's hard and fast. I mean, in federal court, you know, if the parties agree, you can go in and say, well, we'll take the standard discovery platform, and that says X amount of 25 interrogatories, 25 requests, and then other discovery forms are left open, 10 depositions aside, that kind of thing. If it's complex, then you get a few more than that. If it's exceptional, well, then you can blow the top out. And there, though, the parties are agreeing to it, and if they don't do that, then the court can set whatever it wants. But there's not anything actually built into the rules that says it has to be that way. And I guess that's the concern, because if we left it that way, I suppose and this happens a lot, in every judicial district in this state, you can pull out their local rules and there's not a lot of harmony among them. They're all different. Some of them are quite fanciful, and others are just downright ridiculous. So, you know, I'm hesitant to try to encourage anything like that on a local level or on a statewide level beyond perhaps some sort of statutory, enhancement that would perhaps start to embrace the tone of the 2015 federal amendments to Rule 26. But if there's a consensus here that, you know, by God, we need to hammer it out and say this is how many you get of each of these and no more, then we can work on that. I mean, under the medical malpractice arbitration statute, you had 4 hours for 4 hours for the longest deposition of a party or an expert. For anybody else, it was a 2-hour limit. And, you know, federal court generally 7 hours, but the way of calculating that now has gotten all skewed. You know, when you do a 30B6 deposition, it really blows the top out of that. So I just wondered if it would be appropriate for us to, again, to try to lean in the direction of the federal 2015 amendments and those changes, kind of to put a little more meat on the coconut than we had before.
I just feel like that, you know, one of the big keys to getting the parties on the same page is having that early meeting to talk about before. At least my experience has been is that typically at the beginning of the case, you know, you can have a good conversation with the other attorney and work out a reasonable plan that people will agree to. But once you get into the throes of discovery and you start seeing the actual requests that you think are outrageous, that's when it's hard to come to an agreement. And so, you know, that's why I just, you know, really like the sort of the federal concept where you have to have that meeting up front at the beginning of the case and set out a plan, and then everybody has agreed to sort of what the scope of the discovery is on the front end. I think that would prevent a lot of the discovery disputes that we see in state court.
So are we moving toward any kind of a consensus here about what we're going to do about it? Yes, Marcy.
I came, when I joined you guys, I think you, Carmen had just was talking about the existing rules of professional conduct that deal with discovery. I think it would be helpful for us to see those. I mean, I must admit, I don't know what they all are. I'd be curious before we make a decision about which path to take a look at what we have already that deal with discovery and to see if there's anything we can do with those rules. I don't know how you guys feel about that, but I mean, from our, as far as what we can do would be,
yeah, there may be additions, even just to comments if the rules aren't changed, that sort of lay it out a little more clearly about, you know, when you don't get a get out of jail card and that sort of thing.
Yeah.
So
that's just my thought.
That's sort of what I was thinking, is it casting it in terms of professionalism and talking and addressing that and saying, you know, something essentially that it's unprofessional to serve unnecessary discovery or excessively broad discovery. And that would clearly be within our regulatory ambit. My problem is, in the 15 years I've worked at the state bar, I haven't engaged in discovery with a reasonable opponent. So I don't know anything but abuse of discovery. That's all I've experienced in 15 years. So
I can't imagine that anybody's ever received public discipline for a discovery violation, have they, Catherine Jean?
Well, there was certainly one that quite famously did back in 2007.
they have received discipline. Yeah.
For withholding
Sutton.
discoverable information, absolutely.
Are you
and
talking about criminal?
And it was a mixture.
Sorry, Catherine, you got a little bit of a delay.
No, it was in a civil. No, I'll be quiet.
well, I remember being on the grievance committee when we had someone whose last name was Sutton in front of us, and there were clear abuses in the deposition context.
Yes.
And I mean, that really is a feature of proportional discovery as well in terms of the length. So it sounds like, Carmen, there's clearly a consensus that before we go jumping on any kind of modification of our rules of civil procedure, that we want to see we want to see what the state bar has to say about it specifically, if you could enlighten us in that regard.
Absolutely. And I am now reminded that I have some probably entertaining illustrative examples I can share also. So I'll include that in the material.
Please do. Okay. All right. Well, does anyone else have any other ideas about how we should be moving forward? I don't think any of us are wildly advocating any major changes here, certainly in terms of mandatory changes. But at this point, are we comfortable that we will absorb what we can from Carmen's teachings and then perhaps gather again and see if we can get a final plan? I don't think this committee needs to have a lot of meetings. We could always bring Mark Enriquez in it, and it can last several years. But I want to make sure the floor is open. If anybody else has any specific, concrete, commitment that it has to go in one direction or another that we haven't discussed as a possibility at this point. Okay. All right. Silentio es consentio. So I think that takes care of that. Well, who else has anything to bring up before this august body, before we adjourn here for today? I think I make a report to the issues committee, I believe, at our meeting in a week. And I'll tell them that we had a positively lugubrious gathering and maybe add a few salient facts. But other than that, I'll just tell them we're coasting right along. Okay.
Well, I'd like to know what building that is behind Ted.
Fort Knox.
Yeah, it is in North Carolina, but I forget which courthouse it is. I did a search for North Carolina courthouses, and I thought I was impressed by the cannons, and so I picked this one. But I have to say that I don't remember which county it is.
It's a great backdrop.
Quite a grand looking building.
All right, folks, I'm going to stop this live stream before